Hey guys, welcome to this video. My name is John Watson. I'm a consumer protection lawyer in Alabama. And I want to start this new series where we look at some jury instructions. Now, these will be from Alabama, what are called the Alabama Pattern Jury Instructions. And let me first tell you what jury instructions are, and then why they're important no matter what type of case you have. And then we'll look at this specific one that we have on the screen. So, pattern jury instructions, or just instructions in general, that is where the judge tells the jury, here's what the law is. Because the judge is the one that his or her role is to make sure that the correct law is put in front of the jurors. Now, the jurors then will take all the evidence that's been presented and decide who is right and who is wrong. So if we're in a car wreck and I say I had the green light, you say you had the green light, well, the jury will decide who actually had the green light. Now, why would this be important if maybe you don't have a jury trial? Well, because if you have what's called a bench trial where there's no jury, there's just a judge, then that judge not only decides the law, but that judge also acts as the jury and decides the facts. And the beauty of these jury instructions is they take all of the law that applies and they really do a fantastic job of sort of boiling it down to just the essence of the law and put it in sort of understandable, plain English is the idea. And I think that our committee that does this in Alabama does a fantastic job with it. So even if you have a bench trial just with a judge, you want to know, well, what is it that you have to prove? So you look at the jury instructions. Obviously, if you have a jury case, before you file that case, you want to know exactly what that jury is going to be told so that you can make sure as you plan out your case, whether it's a truck wreck case, a fraud case, malicious prosecution case, whatever it might be, you want to make sure that you have the evidence that will satisfy all the requirements that the jury needs. Now, what if you're in front of an arbitrator? You're not even in court. You just have an arbitrator. Well, again, they're looking at what are the rules to decide who wins and who loses. So these are very, very powerful. So this first one we're going to look at is just kind of a general instruction. And it's very common sense, but it's important that the jury be reminded of this. And even if you're trying it to a judge or an arbitrator, you still want to make sure that you know this and that the judge knows this or the arbitrator knows this. So this happens to be Alabama Pattern Jury Instruction 1.07, Interest of Witness. So it says, look, you should consider the interest any witness may have in the outcome of the case. So let me give you an example. It's pretty common for these defense medical experts to be hired. And sometimes they'll evaluate a plaintiff who says that he or she was injured, for example, in a car wreck case. And sometimes they just look at the medical records and they'll say, oh, you weren't really hurt, or you should have been fully recovered in 2 weeks and you're faking it and you're totally fine now. Well, then we get to ask them, well, how much has this law firm paid you this year? Or how much have you been paid by firms representing defendants this year? And of course, I hate to answer that question, but there are some of these guys that they're being paid $900,000 a year, over $1 million a year to give testimony. Now, they will claim and they will swear to you, I am totally neutral. The fact that these defense law firms pay me $1 million a year, and I always testify that the injured person is faking it and it's all a scam. That is no connection. Well, the jury's allowed to consider that. So if you look at the second sentence, it says you may consider the interest or the bias a witness may show while testifying. Now, that may be financial. It may be just their body language. It may be their attitude. So look at the next sentence, third sentence. You may consider the behavior and appearance of a witness. And here's the real key, these last two paragraphs, or last two sentences. You should also use the same standards you would use in your everyday life when you must decide whether someone's telling the truth. So if you're at work or you're in your neighborhood or wherever you are, and somebody's telling you something, maybe two people are telling you opposite things, well, you've got to use your own judgment, your own common sense to decide who's telling the truth. So part of that might be, well, what's somebody's bias or their interest? So the very last sentence says, examine the testimony based on your own experiences, reach a verdict based on what you find is true. So again, this is very useful. Now, for lawyers that try cases, this is standard. We know this, but most jurors in a case, that's their one and only time to be on a jury. And so we want them to know this. We want them to know that they don't have to leave their common sense outside the courthouse. They can bring that into the courthouse and say, that guy that was up there testifying, that woman that was testifying, I just did not find them believable. I think that they were biased. I think they had some self-interest that influenced their testimony. Or maybe the opposite, that nope, they seem right down the middle. They seem absolutely truthful. That's part of what the jury does, or a judge, if the judge is trying it without a jury, or an arbitrator. So again, I hope that you'll find these helpful. We'll go through, there may be another preliminary one or two, and then we'll kind of get into damages and car wrecks and fraud and trespass and all different things that I think that you might find interesting. And let me know if you do find these interesting, and I'll make sure and continue to do them. Okay, you guys have a great day. Talk to you soon. Bye-bye.